Hello, everybody, and welcome to another episode of the Law with Darren podcast. And today I'll be covering another case out of Rhode Island, which covers a little something known as the public duty doctrine. What that is, it's this idea in the law that we as individual citizens cannot sue cities or towns or the state if we are injured because we claim that the city, town, or state did something that injured us, and such as placing stop signs or not placing stop signs at intersections, amongst other actions. But mostly in the law that I see, it comes up where people are injured at intersections and they try to sue the city or state because they say that the intersection is dangerous. There are multiple accidents there. The city or state knew about it and they should have placed a stop sign or a stop light or something or the other. So, actually, I came across a case from... Now, typically lawyers don't like bringing these cases because the damages are capped at $100,000 anyways. But I came across the case of Tugeman versus City of East Providence, where this gentleman, Arthur Togeman, I think is how you say his name, citation 21A3D 384, sued the City of Providence, claiming that and on September 20th, 2007, he was driving in Providence at the intersection of Adelaide Ave and Melrose Street. So I'm going to go ahead and pull up the pictures here. It appears as though he was stopped at a stop sign on Melrose Street. Now, I'm not sure if he was traveling north or south, so I picked the northern view for you guys to look at here. He claims he stopped at the stop sign, proceeded forward, and as he's going forward, he was struck by a car traveling on Adelaide Avenue. So, what does he do? Well, it sounds as though he's at fault because he had a stop sign and didn't see the other car. But he decides to sue the City of Providence, claiming that the intersection is unreasonably dangerous and that they should have basically made it a four-way stop. So, what happens? He couldn't find a lawyer, I guess, to bring this case because he ends up filing and doing all this work pro se. So all on his own. So props to him for doing that. It's not an easy process. I know lawyers that would screw this up. So he files a complaint. It goes before a judge in the Superior Court. The city argues that under the public duty doctrine, they cannot be found liable, and the lower Superior Court agrees and dismisses the case. Plaintiff files an appeal, and the Supreme Court agrees with the other court, with the lower court. So upholds the lower court and dismisses the plaintiff's appeal, basically on the grounds that this case and these facts fall squarely within the public duty doctrine, and it does not fall within any of the exceptions. So again, you cannot sue a city or a town for doing a function that is purely and only performed by cities and towns and not by private persons. Placing stop signs and the decision or the discretionary decision to place stop signs and traffic lights are purely within are purely functions that are only performed by cities or towns. People just don't do that. You can't go to a intersection and throw a stop sign up. That's illegal. You'll get in trouble for that. So do not do that. But the court did cite three little exceptions to the rule, which I'll go over with you guys quickly. The first exception is that when the allegedly negligent activity are normally performed by private citizens, so again, this doesn't fall within that area because, like as I said, and as the court said, and as we can all agree, placing stop signs and traffic control devices is purely a function that is only performed by cities and towns. The second exception is when the plaintiff establishes a breach of a special duty owed to the plaintiff. So, in this case, the plaintiff in this case could not point to any special duty that was owed to him, Mr. Arthur Togeman. So he's going to fail there. Exactly what a special duty is, I'll try to find some case law on that to see how someone could prove that they themselves were owed a special particular duty by a city or town. Because cities and towns work for everybody, not just one person. So I don't have anything on that just now, but I'll come back to that if I find anything. And the third exception is when the state engages in what's known as egregious conduct, which is when the state has knowledge that has created a circumstance that forces an individual into a position of peril and subsequently chooses not to remedy the situation. So, I mean, I guess the issue is, if this intersection is super dangerous, I mean, if there's accidents here weekly, you could say that, maybe the state or the city in this case would be egregious to not put up a stop sign. But even then, you don't get past the other prong, which is that Mr. Togeman cannot argue that they did it just for him, right? So, I mean, maybe an example would be if a city builds a road where there was no road at one point, through someone's land, and, this person is the only person on that, on that road, and it's on a blind curve, and they've asked the city to put a stop sign or a yield sign for their driveway. Maybe that might fall within some sort of, egregious conduct, which, the city or town could be sued, especially if the owner of the land, as a part of the deed, giving the land to the city, asked for that and they didn't do it. But that would probably be a breach of contract. But anyways, so long story short, can you sue a city or town for not placing a stop sign or a traffic control device somewhere, even if the intersection is super dangerous? No, you cannot do that. That falls squarely within the public duty doctrine, as it is only an activity that is normally performed by a state, a city, or a town. So, I hope you guys enjoyed this one today. I'm going to post some of the pictures here for you guys to see. By the way, I'm looking here, and I can understand what the plaintiff is saying. I mean, this is a pretty dangerous intersection from what I can tell, because if you're on Melrose Street, as you'll see here, you do have a stop sign. The plaintiff probably thought that the cross traffic on Adelaide also had a stop sign. And I can see why he would think that, but obviously he guessed wrong. And this is a very weird road where, it narrows. So 2 cars really can't make this work, which is very odd. If you look, I don't see how, 1 car coming in and 1 car going out on Melrose Street. And Melrose is a 2-way road. It looks like the 2 cars would actually hit. So I can understand why, the city doesn't want people stopping as close to the intersection as they should. I mean, you can see where the stop sign is and where the stop line is. The stop line is right by the word Melrose. So, yeah, no, it's definitely an odd intersection, and I can understand why somebody, especially if you're not familiar with the area, would believe or think that it should be a 4-way stop. I mean, it is a residential neighborhood. But, again, doesn't help him now. He was most likely found at fault. His insurance company, if he had insurance, definitely paid this one out to the other party. So, hope you guys enjoyed. If you have any questions, like, comment, or subscribe. Leave me the questions. I'll try to answer it for you. And until next time, have a good day.